Hi, this is Steve Danz, senior partner at Danz Associates. As you know, and you're probably visiting our site for the first time, we do employment law. We represent plaintiffs only throughout the state of California and nationally, whistleblowers under federal false claims and IRS tax fraud. Today we have a very special guest who practices real estate law here in California. Marty Rudoy is also the founder of a really great attorney networking group called TEN. And I thought before we got into it, we have the coincidence of a great picture here in our conference room, and it shows real estate that Marty practices in many different forms right here in one picture. What are the odds of that happening? We have downtown commercial skyscrapers, we have light industrial parks, we have potential residences, all has to do with real estate, meets and bounds, and even eminent domain issues having to do with the right of a public entity or a railroad, for example, to take over the property. Marty, does that fairly encompass the world of real estate?
Sure. I've litigated most of those issues.
Okay. And how long have you been practicing real estate law?
I've been a lawyer since 1974, and most of that has been doing real estate law.
And what got you into that in the first place?
Well, you know, attorneys don't always set their own direction. It depends on where you get your first job or where you get your first clients. One of my first clients was the manager of, it turned out to be the largest realty company in Wisconsin. And so we had successful interactions, and I started meeting a lot of real estate brokers. And so I learned real estate law very early and quickly, and that set the course for the entire career.
And so, would that include things like landlord-tenant? Is that considered real estate law?
Sure, I do landlord-tenant, I do eminent domain, I do easement problems, title problems, disputes between owners, among owners, and claimants, lien claimants. I do disputes among owners and neighbors. Every day it's a new dispute.
So everything real estate, Marty Rudoy.
Everything real estate.
And where is your office located?
My office is in Encino, California.
Okay. And are you able to visit folks, some of, for example, might live in the Inland Empire, have
Sure.
just inherited some property, they're elderly, they don't drive. Would you be able to help that kind of person?
Absolutely. I'll go anywhere, we'll meet at Starbucks, and we'll have a conference.
Okay, well that means you now have 6,000 offices if you meet at Starbucks.
Exactly.
That's very good. Any fascinating cases in your recent caseload that you'd like to share with the audience?
Well, we had one case. It started as kind of a property dispute, and it turned into a murder investigation. It was a woman who died in an oceanfront mansion in Coronado, and it became a wrongful death case. Although we thought it might be premises liability, where the landlord had responsibility for the death, it turned out that someone actively was involved in her death, and it's still classified as suicide by the sheriff, but we proved that it was a battery that led to her death.
Amazing. But it started as your involvement as a premises liability
as a real estate
issue?
case. I have another case. Again, it was in what is called an ejectment, when one person locks out a roommate or a person they're living with, and that's turned into what's called a Marvin case. It's kind of a divorce among unmarried people.
Okay. And where do you see real estate law going? Will it continue to be an important driver of the California economy in the next 10 years, let's say?
Absolutely. The reason I got into real estate law is I learned that if people were going to spend money on an attorney, it was going to be over their biggest asset. And for most families, their biggest asset is their home, their real estate. And so that's going to be true no matter what happens.
And when it gets to issues of title and asset protection and inheritance, do you do those types of things yourself? Do you use other attorneys from TEN to form a team? Do you refer the collateral issues out other than the actual titling of the property?
I often bring in specialists in other areas. For example, I'm not a family law lawyer. In this Marvin case, I brought in a family law lawyer to litigate those aspects, but I handle the real estate aspects.
And so you would work as a team. You could be the captain of the John or Mary Smith.
Absolutely, and we work We work to keep the client's costs down, so that if I'm talking to the other attorney, we don't bill my time for that.
Excellent. And how long would it take to resolve a typical title issue, let's say? There's a fight between heirs on who's on title, who's not. How long does that take to resolve on average?
Well, any litigation normally goes for about 14, 16 months in Los Angeles. If you can get parties into an early mediation, they can control their own destiny by coming up with a settlement. Because if you go to court, it's just a settlement imposed by the judge. And you might as well take your own future into your hands and develop the best settlement you can that turns out, hopefully, to be a win-win for all parties.
So,
not always possible, but that's the goal, to get the best deal you can, as soon as you can, as cheaply as you can.
and so that is what a lot of our audience are probably aware of as being called alternative dispute resolution, correct?
Exactly.
And so what are the various 2 or 3 different main branches of alternative dispute resolution?
Well, you've got mediation, which is a voluntary process, and people have to agree to a settlement, or else, it fails and you have to do something else. There's arbitration, which is really like a private trial. A lot of family disputes, they'd rather go to arbitration, so you're not opening up the family secrets to the public, because courts are public. And then there's something that's not very often used called judicial reference, where you hire a mediator or an arbitrator to actually judge the merits of your case, and they give their opinion. Personally, I don't like doing that because I already got a judge. I don't want to hire another judge. I just want to get my cases settled. And so my mediations tend to focus on the dollar issues, not the legal issues.
So in conclusion, it sounds like you've got the best interest of the client at mind by trying to cut to the chase, resolve the issue, move on, not necessarily building a trial record for yourself.
Right. Less seasoned attorneys think that if you try to mediate a case too soon, it's a tell that you have a weak case. On the other hand, you have a strong case because you know what your position is. You've already evaluated the potential damages. You know your case. And so going to mediation early is just smart litigating.
And if somebody, in conclusion, would like to contact you, what's the best way to do it?
They can call me on my cell, 818-730-7314. I'm always available.
And do you have a webpage as well?
I do. RudoyLaw.com.
RUDOY.com?
RudoyLaw.com.
RUDOYLAW.com.
Yes, sir.
Thank you very much for your time.
Thank you.